It is 2 p.m., January 11th, and I call the Code Enforcement Board meeting to order. Madam Clerk, would you please call the roll?
Mrs. Archer?
Here.
Mr. Weeks?
Here.
Ms. Dabbs?
Here.
Ms. Wade?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
And Mrs. Norfleet is absent. Okay. That completes your roll call, Miss.
I'd like to ask Mr. Trask if you'd please give the invocation and lead us in the Pledge of Allegiance. Would everyone please stand?
Father in heaven, we seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm going to read the procedures at this time. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statutes 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of the board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. So if there's anyone going to speak, would you please stand and raise your right hand?
Do you swear the testimony you're about to give us the whole truth and nothing but the truth? I do. Thank you. Can you see it?
Okay, it's a new business. Item number 1, 17-800000456, 431 Grand Boulevard. Stavros Salikas, are they here? Would you like to go to the podium, have a seat, and give your name?
My name is Stavros, but they call me Steve.
And your relationship to the owner of the property?
I am the owner,
You're the owner, okay.
home owner, property in the state of Florida.
Would you have any objection to the city's documents or photos being put in for evidence?
May I have a second to take a look?
Looking at them. No objection?
What else?
Okay, then we ask the clerk to receive these
Is that
into
all?
evidence.
Is this the only thing that you have?
Yes.
Okay.
Officer Gasser, you ready? And
This is case 17-0800000465, 431 Grand Boulevard, Stavros Salikas. I am Shannon Brewer, currently employed by the City of Tarpon Springs. I'm an ISA certified arborist, license number FL 9221-A. I'm also an FNGLA certified horticultural professional, license number H978402. All the photographs and exhibits that were given to the violator, exact copies of what being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and the Tax Collector Database. All NOVs and NOHs were sent certified return receipt and first-class mail. Please accept all exhibits into the record as evidence.
Could we make one correction? She transposed two numbers when she gave the case number. So let's
need
make
to
sure we got that straight.
I need to fix my case number, 17-800000456.
Thank you.
A call came into the office July 27th, 2017, stating trees are overgrown and blocking the line of sight at the stop sign. I was unable to inspect until August 4th. Upon inspection, confirmed the complaint. The required right-of-way lines were blocked by 3 overgrown trees. I marked out visibility triangle in orange paint for the point of reference. Tree number 1 was a camphor, was in severe decline, dead hollow limbs next to the roadway, a large codominant trunk originating 2.5 feet above the ground, which were weakly attached and hazardous to persons and property. Tree number 2 was a cedar, in good condition, has several lower branches blocking the view. Tree number 3, a rubber fig, had overgrown into the camphor, had low limbs blocking view. At the time, to bring them into compliance, tree number 1 needed a full removal due to its hazardous condition. Tree number 2 and number 3 needed to have 8 feet of clear trunk. They obtained a permit 17-2027 for removal on August 18th of 2017. On September 1st, 2017, Elaine Ferris called on behalf of Stavros Salikas to inform she and others would be addressing the yard issue as well as the camphor tree, but needed a 2-week extension. An extension was granted by another city arborist, Greg Dobbins. On October 6, 2017, a reinspection occurred, and the trunk of the camphor was measured at 5 feet high. The trunk is still blocking the visibility, and the property was not in compliance. A phone call was placed to homeowner, and the homeowner was granted another extension because he claimed he could not get a company to remove the stump due to Hurricane Irma. On December 18, 2017, a reinspection was conducted. The trunk was not removed. The tree was trying to regrow, which again was blocking line of sight. Property was still out of compliance. On January 10, 2018, a reinspection was conducted, and the trunk had grown more sprouts, and the property was currently out of compliance, and the trunk still needs removal. That's the end of my testimony.
Does the board have any questions for Shannon? Okay. Mr. Salikas, do you have any questions? Just questions at this time?
We have a few comments.
Okay, you can have that. No, you don't have any questions?
Oh, yeah.
If you have a question,
Well,
No.
no, right now.
No.
We're trying to figure out how to approach this thing because it's very serious and my life depends sort of. Okay?
all right, you can now present your case.
We have.
Hold on a
here-
second. Who are you?
My name is Elaine Saris.
And who are you? How are you related to Mr. Salikas?
We're
I am
cousins.
Mr. Salikas.
Okay. Are you an attorney?
No,
Okay. Are you going to be testifying then?
my testify.
Yes.
I am going to be giving.
Okay. You're going to be testifying. Were you sworn in earlier?
Yes.
Okay. I just want to make sure. Thank you.
Yes. We see the exhibit here that was turned into everyone, taken at the most optimal angle.
You gotta
of
use the
where-
microphone or we can't hear you.
Okay. Okay, we're looking at the photo here that was turned as an exhibit, taken at an angle to make it look most like this tree would be blocking the view of vehicles. This is an actual photograph of the yard and the tree, which you can see all of the new growth. This is a healthy tree. It's not dead. It's not dangerous. It was, in fact, probably the healthiest plant in the yard. There are not lists of any incidents, accidents, any issues occurring because of this tree. This tree has been in this yard since 1948. It hasn't caused a problem. And unfortunately, this particular complaint, and if you'll grant me a little leeway, I'm going to diverge just a bit, is a pattern of harassment that has been levied against Mr. Salikas
Objection,
and his
relevance.
property.
Okay, hold on a second now. Madam Chair, there's an objection to this line of testimony, and so you need to decide whether or not you're going to allow this line of testimony to continue on. And if you are, you would overrule the objection. If you're not going to allow that line of testimony, the harassment aspect of it, I'm assuming that they're dealing with, then you would sustain the objection, and then
I'm
this
sorry, I can't understand
this
what you're
discussion will no longer be allowed.
No, he's talking to her,
So
to her, to the chair.
you need to make that decision. Sustain or overrule the objection.
The information that I
Hold on a
have is
second.
pertinent to the
Hold on a
case.
second. Okay. So,
Of the harassment.
yeah. Okay.
No,
Let's hear. Do you have some additional argument that you want to make as to why that the testimony that you have should not be sustained or overruled? Do you have anything to add to that? A legal objection?
But,
yes,
excuse me,
Steve,
is her testimony not
hold-
being sustained? What are you saying? I don't understand.
Steve,
May I show you these pictures, please?
we did, Steve.
No, I want to show them real close.
No. Hold on, sir. This is a quasi judicial proceeding.
Pardon, sir?
It's a
You have-
quasi judicial proceeding. This is like a court hearing.
You have to sit still
And there are
and be quiet.
procedures and processes that we have to follow. And so what we're trying to do is to make sure that those processes are followed. Right now, there was testimony by your witness that was objected to. And so the chairman has to make a decision whether or not that she's going to allow that testimony to continue. So she'll have to either overrule the objection or sustain it. And my question to your witness was, since neither one of you are lawyers, is do you have any legal arguments that you want to make as to why the objection should not be overruled or should be overruled? In other words, relevance. How is that relevant?
I understand what you're saying.
Okay.
And no, I am not an attorney. I do believe that it is relevant because this is, it's a chain of events. There have been several complaints made by the same anonymous person. That same person has, in our view and the view of many of the surrounding neighbors in this area, used the resources of the city for her own personal ends. This gentleman is in his 80s, living on a fixed income. At the moment, as of today, at $50 a day, there are fines levied against him and his home in the amount of $29,000 and $60, stemming from a previous complaint.
Okay, you're getting off course.
I understand that.
I was asking you as you could explain
no,
relevance.
I understand that, but I promise that it will become clear, like I said, if you'll just allow me a little leeway.
Madam Chair, she's getting out of the line, and so you need to make a decision whether you're going to sustain the objection or overrule it, because she's continued to narratively explain things that have no relevance to this particular code
I
enforcement
assure you
proceeding.
they have relevance.
We should be allowed an attorney.
Steve,
If an attorney
Steve,
is going to
Steve.
rescind everything we
If
say.
if the objection is that if you agree with this, the objection, you would sustain it, otherwise you would overrule it.
From what you've said, I think you've gone far enough, so I'm going to sustain.
Okay. So ma'am,
Okay.
so if you could just stick to this case then and not,
What does that mean? We're not allowed to progress?
No, Steve. Don't.
sir, you're not allowed to continue on with the testimony relative to incidences that have nothing to do with this case.
Okay, Steve. Calm down. You're not. You're here to be railroaded.
I'm being railroaded.
No, Steve. Steve. Please stop. Steve. Don't.
not the end of it.
Steve,
You could just continue on with your case relative to why you think you're in
how do we
violation or
get
not.
a previous case back on your agenda for the next meeting? One that was not addressed by the city? No.
The cases that have been heard prior by this code enforcement board, if they were not appealed within 30 days, then this board does not have jurisdiction of that case, okay? So if you're talking about cases that were not filed at all, well, then this board does not have jurisdiction of the case.
I understand that. This gentleman does not have the financial means to obtain an attorney. At this point, if you cannot allow a small indulgence,
Just present whatever testimony or evidence that you have as to why you believe that the property is not in violation of the code. 99% of the people that present before this board are not represented by an attorney. You don't necessarily need an attorney. This is not a criminal proceeding.
I understand that.
So just tell us why you think that it's not in violation.
What I would like to say is that we have been told, Mr. Salikas and his neighbor have been told, that there are 10,000 violations all over the city, but that unless someone calls to complain, they are not addressed. And what we are saying is that they are being unfairly harassed. At the same time, the person by whom they are being harassed has created conditions on their properties that are untenable and have not been addressed. What we are asking is simply a fair and balanced addressing of issues brought before the city and assurance that citizens are treated fairly and without discrimination.
Sorry, you have to say?
This is, he's already been forced to pay for a permit, which he could not afford. Now they want him to take out a tree, which I invite y'all to go stand and look at the property, is not a hazard as far as view goes. It has been there since before my childhood. Like I said, there are no records of incidents being caused because of the existence of this tree. It would be incredibly expensive to have the tree pulled out, and a shame to take out a tree, you know, of such aged and venerable growth, which is obviously healthy and, you know, and not dead or dangerous. That's this one single issue. The other issue is that besides this poor gentleman is being fined to death by the city. He cannot possibly afford these fines, and that issue at hand is being caused by another complaint that the city chose not to address. What I'm saying is that it's not fair to address the concerns of one citizen and not another. It comes across as, you know, as preferential treatment or harassment, and I know that that's not the intention of anyone here. It wouldn't be the intention of anyone fair and decent, and we're simply seeking fair and decent treatment for Mr. Salikas and for his neighbors who have been harassed, who have had their property damaged, and have not had their concerns addressed.
That it? Does the board have any questions? No?
I do have a question for for our expert over there.
Just give her a little bit of leeway to do it. Yeah.
Go ahead.
And, okay, the property in question, Mr. Salikas' property and the property next door to him, is that property classified as marshland?
That's irrelevant. This is dealing with a visibility triangle.
I
don't know.
You
I
don't
never
know.
looked into that
Okay.
a property adjacent.
Okay, the board has no questions?
If you were
Miss-
looking at the property, you would have noticed marsh pennywort or pennywort growing all over the properties of Mr. Salikas.
I
and
was,
Mrs.
I was
Stanton.
there to inspect the visibility triangle under section code 37.
Mr.
There
Epps?
All right.
Mr. Epps, have a question?
There are two photos she has. One says the tree is in violation and the other one doesn't. How does this board determine which one to?
I'd like to turn the
I-
table
she was
for
asking-
police.
This, I mean,
We can get into that in the discussion portion when the motion is made. At this point, it's, do you have any questions of any person that has testified? And if you don't have any questions of who is testifying, then we'll allow them to present rebuttal, or they can give their summary of the case. And then once a motion is made, I'll try to help you answer that question. Any objection to those photographs coming into evidence?
I think she has an objection to one.
I don't know anything about this tree,
That's
Can't tell
the
what
tree in
tree it
question.
is, where it was taken,
where
when.
it says
Yeah, it's the
1948.
same
The
tree.
yard looks larger because a large part of Mr. Salikas's property was taken by the city through eminent domain.
This photo actually does show more of the visibility triangle issue. If you notice on the bottom, there is the orange paint, and it's kind of at an skewed angle because of the overgrown of the yard on the curb, where it's the tree and the stop sign, it's in between.
Okay.
And do you want me to explain a visibility triangle?
No,
Is
right
that-
now, we're just trying to determine whether or not you have any
Oh.
objections to the photographs coming into
Not
evidence.
this one.
Okay. And as to the other photograph, you just don't recognize it? That's not a legal
That's
objection?
not what I saw on the property.
Okay, so Madam Chairman, I would suggest that you go ahead and receive both of those photographs into evidence, and then give it whatever probative value that it has to the board members, and that's, we'll get into that a little bit more, Mrs. Dabbs, but
I do have a question for the expert. I'm wondering, the stop sign that was placed on Mr. Salika's property as a matter of necessity, because it's, there's no city property available there. They've already taken what they were able to of his yard. Whenever you are heading east on Hope Street, approaching the stop sign is in front, several feet in front of that tree. So how is the tree blocking?
The visibility triangle is based on the apex of it, and in the code, it says it's 30 feet from the apex on both sides. Anything in between that, under the code, states it has to be under 6 inches. The line comes out to here, there is the apex, and everything from here over must be under 6 inches, starting at 3 feet tall and to 8 feet above grade. That is not 6 inches.
Does the city have a list of traffic incidents that have resulted as the?
It's
from the
irrelevant
exhibit?
for this, it's the visibility triangle.
Well, how is it irrelevant?
ma'am, so far, the chairman has allowed you a lot of leeway.
I understand.
She's first asked you
And I-
whether you had any cross-examination. You said no. She's allowed to open it back up to ask a couple more questions. Any other questions that are relevant to this case, not any other traffic case, any other with this case?
Well, it's the tree in question, so,
Any other questions?
okay. Yes, I do have one more question. So if the city took Mr. Salika's property through eminent domain, needing to widen the roads or whatever, they took his property to place a stop sign for safety's sake, and we get that. Yet, because the city has taken his property, how is it his financial responsibility to have to pay for the removal of this trunk when it was not planted originally in a spot to be within the visibility triangle?
Do you have an answer to that question?
Dictated by code 8-40.
Okay. She's answered your question. Any other questions? Okay. Any
Do
cross-examine?
you have any questions?
No.
Would you like to summarize?
Do you understand the visibility triangle and it's defined, then no.
Not really.
Oh, you don't?
No.
Okay, from the apex of a corner, you measure 30 feet to 30 feet. That'd be side A and side B of a triangle. Along side C, which would be the hypotenuse, everything towards the corner has to be within 6 inches.
Can I ask a question?
Yes.
What's the issue? Is the tree blocking the intersection so cars can't see? Is
Yes.
that the problem?
Yes.
Okay.
No,
I'm not asking you, I'm asking her. Okay.
And is that because they've widened the road? Is that the reason that's happening? Or?
I know nothing about the road. I was there on that day, at that time, at that moment.
I went out with Shannon. We initially got the complaint. I kind of let her handle it because it's more of an arborist type thing with trees. It's a substantially large tree. I'm sure in 1948 when it was planted, it's fairly small. The roads were completely different. Unfortunately, as time progresses, this tree got extremely large. The sign is placed where it's placed, probably because the tree is so big, you can't actually place it right at. It's very small property line. But I helped her measure that, so that tree is well within that visibility triangle, and it does cause a significant view problem, even from the photograph that was presented by her testimony at an optimum angle blocking the view. Well, it doesn't matter what the angle is, it blocks the view, and that's the nature of this complaint.
Is there anything else that you'd like to? James?
This comes at a very convenient time for a builder called Tagarelli Construction.
Objection, relevance.
Wait a minute, this has everything to do with it because their mother has been after me to take my property and use it as a parking lot for the shrine. She is a caretaker, not the owner. It is in the family trust. And she was telling my neighbors and everybody who would listen, everybody that she was using code enforcement, the police powers of code enforcement, to code enforce my property and take it and use it as a parking lot. Now that the city, I have it right here, they're having a meeting to get an approval, to get approval to build a multifamily unit on a big lot that she is now using as a parking area. So that means that when they develop that big old lot, then my property becomes prime for their parking lot for St. Michael's. I'm not against St. Michael's. I love the people that come there and pray. But she's been doing this over the years. She's trying to force other people to sell her their properties, and I'm not the only one.
Steve,
There have been several.
We have to address this.
This is part and parcel of the whole thing. It starts
That
with
has
somebody
anything
else.
to do with
It
the
is, but
tree.
we have to address this.
I think
Yeah,
we
but
need to
it's
stop.
this is the reason
Steve?
why I'm here.
No, it's not.
Like to
We
make a
talked to the
motion.
mayor. Wait,
No,
my neighbor and I
Steve?
talked to the mayor. I could say,
Steve?
listen,
No.
we talked to the mayor,
Sir,
and the mayor told us
sir,
they
this
would
is your
not act. There's
opportunity to make a
1,000
summary.
Okay.
You need to summarize your case. The testimony has been closed, and so you need to summarize your case. And it would be something along the line of, we believe that we've provided sufficient of evidence to show that there is no, in fact, no violation of the city code section 37.00, and these are the reasons why, and you're asking the board to find a non-violation. Do you have anything like that you wanted to present? Because we want to stay right on track with this particular case. No? Okay.
Okay, I'm going to close the public portion of this case now, and I'd like to entertain a motion.
I make a motion, based on the testimony, evidence, and facts presented in the law, that at the time the alleged violations, sections 37.00 and 133.02 of the Code of Ordinances for the City of Tarpon Springs was in force and effect, and the respondents were in violation thereof.
You have a second?
Second.
Is there any discussion?
All right, here's where I wanted to jump in and talk to you about the photographs. Mrs. Dabbs had a question about the photographs. And obviously, that's one of the harder decisions that you have. You have to weigh the evidence that you see. You have to give whatever weight that you want, that you think is more probative. In other words, if you believe the photographs that are being presented by the respondent as being more accurate than the photos being presented by the city, you can give that more weight. But you know, if you're asking, you know, whether or not, because they're at different angles and so forth, then you need to take that into consideration when you're making your motion. But really what it boils down to is that, and I'll read this code section to you so that everybody understands the actual code section that's being cited, because it's dealing with feet, the number of feet from the corner. It says 37.00 parent A says, on every corner lot, the triangle formed by the required right-of-way lines and the line drawn between 2 points along the required right-of-way lines, a distance of 30 feet from the intersection of said lines, shall be kept free of obstructions, such as lateral vision is kept clear between 3 and 8 feet above grade. So you're going to go back 30 feet each direction, and you're going to join the line. If there's anything in that triangle that would block or obscure view, then you are to find a violation. There's another portion of the code, the same code, dealing with driveways. It's a little bit different. It's smaller. It's 15 feet and not 30 feet because it's not an intersection. It's a driveway. So I'm not going to read the rest of that. But let me read to you the other code section that's been cited, 133.02. One 133.02 is titled Applicability and Maintenance of Trees for All Properties Within the City. Subparagraph A says the terms and provisions of this section shall apply to real property within the limits of the city. Subparagraph B says owners of private property are responsible for the maintenance of trees in private property and in abutting rights of way unless otherwise provided in section 133.00 through 133.10 of this code. Where support, staking, and guying of vegetation is provided at the time of installation, the stakes and guys shall be removed no later than 1 year after the installation to prevent damage to the vegetation. Owners of private property who are responsible for the maintenance of trees on private property and in abutting rights-of-way shall not be required to pay to remove or replant any tree that they can prove by substantial competent evidence was fatally damaged by any public utility company, as is otherwise provided in sections 133.00 through 133.10. Subparagraph C says trees shall be maintained by the owner, tenant, or their agent in good condition so as to present a healthy, neat, and orderly appearance. All plant materials shall be maintained free of physical damage or injury arising from the lack of water, chemical exposure, insects, disease, blight, or other cause. Exceptions regarding damage due to the lack of water shall be made when water consumption is limited by emergency orders or declarations by state or local agencies. Subparagraph D, except for those tree species listed as exempt or following a declared state of emergency in which trees become damaged in such a way that topping or excessive pruning by or at the direction of a governmental agency becomes necessary, it shall be unlawful for any person to cut down, damage, top, poison, or in any other manner destroy or cause to be destroyed any tree, regardless of condition, with a DBH, that's diameter at breast height, of 4 inches or more without a permit. Not more than 1/3 of the tree canopy shall be trimmed or pruned in any year unless it is dead. There shall be no topping of trees. Top trees and trees destroyed by improper trimming shall be replaced with the same species, minimum 1 inch DBH, and with the number of trees equivalent to the total inches DBH of the topped or destroyed trees. And then the rest of it goes on talking about mangroves and tree trimmings. But paragraph S says it is unlawful for any person to permit or remain on any property owned or occupied by such person, including the abutting rights of way, any tree or tree branch that is in such diseased or dead condition so as to be a danger of falling upon the right of way or the property of another. So that was basically the reading of those two code sections. I'd be happy to answer any questions if you have about either one of those. There is a motion on the floor to find a violation of both those code sections at this point.
Well, that tree apparently has been there for many years. And is it because it's grown that all of a sudden it's obstructing the traffic? Or I don't quite understand why all of a sudden it needs to be taken down, other than a complaint.
Yeah, well, the testimony that you've received so far is that there was a complaint. The code enforcement department went out there and found that there's a violation of the code because this tree exists in the visibility triangle. It's greater than 6 inches in width. It does not have a clear view through it, and so it's a violation of the code. So, as for it growing, obviously, that's the purpose of this code section is to make sure that things that grow don't necessarily cause issues relative to right-of-way view, whether it's leaves, branches, or the tree trunk itself.
Anybody else have anything they want to talk? No? Then I'll ask for a roll call.
Mr. Robinson?
What are we roll calling for?
So far, you've got a motion on the floor, and the motion is to find a violation of these two code sections at this property at 431 Grand Boulevard.
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
Shannon, do you have a recommendation for time frame for the compliance or daily fine?
$30 and $50 a day.
Congratulations.
Mr. Salikas, what his recommendations are.
Mr. Salikas, do you have any input on the compliance date of the daily fine?
Say what?
You have been, they have a recommendation to give you 30 days to get this taken care of or be fined $50 a day.
You can find me anything you want, lady, because I'm not in violation of anything. I would be polite. Look, this is a kangaroo court, man.
Steve.
FSU? I went to FSU. I'm a graduate at FSU.
Okay, I guess he has no other
All
input.
right, let me
Okay.
relax here. I gotta say something.
Okay, I'm gonna,
It doesn't matter, does it? You already voted against me, right? Why did I
Sir, we're not
hear
done
when
yet.
It was predetermined that you're gonna say, come out with a 30.
Sir, the code enforcement board is not complete yet, so they haven't made a ruling on,
You should appoint an attorney to defend us. If you're gonna sit there and tell all these people how to vote,
thank you.
why don't you provide us an attorney to defend ourselves?
Because this is not a criminal
Well, it
proceeding,
is a
sir.
criminal court in this damn case.
Steve,
It's my life you're doing right here, man.
Steve.
I'm 80, I'm gonna be 81 next month. You understand? I've been living peacefully in that property most of my life. That tree that you saw, that little picture, can I show it to you? My
Sure,
mother
we've
had
seen
that
it.
planted when I was a child. It was in the middle of our property, man. It wasn't on the street. And there was no issues about that tree. Why all of a sudden now is it an issue? 60 years later. Why? Because there's a person who is the instigator and the perpetrator. I'm the victim here. Victim. I am the victim. You guys voted against me. Great.
hey, Mr. Salikas, we
The
need to
place
go
of my
on.
birth.
Steve, we need to go on.
What?
I need the board to
Congratulations.
entertain a motion for the,
Cases.
I move that the
Clerk?
respondent shall have until February the 9th to bring the property into compliance with code sections 37.00 and 133.02, or suffer a fine of $50 a day for each day thereafter, and the respondent remain in violation of
And if the
said code
respondent
section.
doesn't have the financial ability to,
Hold on a second, we have a motion.
need a second?
Yeah, I'll second.
Any more discussion?
Could you give me the date of compliance, please, again?
February 9th?
Thank you. 2018, okay.
Yes. Okay, roll call?
Yes, ma'am. Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Mr. Weeks?
Yes.
Ms. Archer?
Yes.
Motion carries.
Okay, Mr. Salikas, you have until February 9th to get that tree out, the stump out, or you will be getting a $50 fine per day after that.
That's wonderful.
You will receive an order within 10 days, and it will be mailed to you.
Are they gonna put me in jail? What are they gonna do?
Thank you.
Thank you.
Okay. So the next one?
Yep.
Okay, we have a, next item is 17-800000286. It's to be established. What's I forgot what VL.
Vacant lot? It's a vacant lot?
Vacant lot on Belcher. Carrie Monacandelas. No, she's not here?
Thank you, ma'am. I'm Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. I've been so employed since 2015. I'll be presenting before the board a number of exhibits. Exhibit number 1 is all the photographs, to include my inspection photographs pre and post. All the notices, to include the notice of violation and notice of hearings. All of my administrative documents, to include the case summary, property appraiser, and tax collector records, and my officer, any emails that were exchanged between myself and the respondent. Exhibit number 4 is the affidavit of posting and a copy of the sign. All of my photographs and exhibits that were, well, the violator wasn't here, but they would have been exact copies if she was, so. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collectors databases. Please accept all of my exhibits into the record, ma'am.
Madam Clerk, you will receive those into evidence?
Yes, ma'am.
Initial inspection on this property, and just so the board understands, this property is currently in compliance, so it's here strictly to be established. Started out on May 20th of 2017. The lot was overgrown. We found through research of a 2012 case, this lot is over 10,000 square feet, but in 2012 it was completely cleared and bush hogged. So consequently, the requirement under 852 is that property be continually maintained in that manner, and the 30-15-15 rule no longer applies to this property. I re-inspected it. First off, about May 22nd, we sent an NOV to the property owner. They requested a 2-week extension, which we did grant. I re-inspected the property on July 1st, and there was no change. We gave them, for whatever reason, they had a significant period of time from July 1st to December 9th, where I conducted the next re-inspection and observed the property was still not in compliance. There was a flurry of emails and conversation between myself and the property owner, mainly regarding the 30-15-15 rule with the property and bush hogging it and so on and so forth. We did have one issue that was brought up during that long time frame, was the gopher tortoise issue, but that was taken care of in a moot point. On December 22nd, we mailed the amended notice of violation and NOH. The amended NOV stemmed from a tree that had fallen on the property during the storm, so we had to amend that to get that tree taken care of as well. On December 29th, I posted the property, and an affidavit of posting was signed. On January 10th, they conducted a final inspection, and the entire lot had been cleared. So before the board, I would like to have them consider violation of 8-40 and 8-52, and also 13302 that were in violation at the time, but as I stated, they are currently in compliance, and I'd simply like to have this property established.
Okay, does anybody have any questions for Officer Gasson?
Would you restate which violations? I've got 8-40 and 8-52. Are you saying there's a third one?
Oh, no, we don't need to, I'm sorry. 13302 is not for the board to consider, so just 8-40 and 8-52, my
Thank you
apologies.
for that clarification.
Entertain a motion?
Yeah, just make a note that there's no one here in the audience for this particular case.
Okay. I'd like to entertain a motion to have this established.
I move, based on the testimony and evidence of facts presented in the law, that at the time of the alleged violation, sections 8-40 and 8-52 of the Code of Ordinances for the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Is there any discussion? Anybody have a roll call?
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Ms. Archer?
Yes.
Motion carries.
Okay, under our next item, 17-800000588. This is to be established at 1403 Glendover Court. Sarah Stillman, is there anyone here? Come up. Hi. Would you give us your name, and are you the owner?
I am the owner.
And your name, please?
Sarah Stillman.
Oh, you didn't get sworn in before?
I did when I did. Yeah, I did.
Okay.
Any objections to those photographs?
Do you have any objections to the documents or photographs? Okay, then I ask Bobby, should we see those in evidence?
Yes, ma'am.
Mr. Gaston?
Thank you. Case 17-800000588, property address 1403 Glendover Court. Sarah Stillman is the property owner here. As previously stated, I have 4 exhibits before the board. My photographs, including my inspections. Exhibit number 2 are all my notices, including the notice of violation and notice of hearings. Exhibit number 3 is my administrative documents, case summary, property appraiser, and tax collector records, and any emails. Affidavit of posting and a copy of the sign is exhibit number 4. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All the notices were mailed to the property owner of record according to the Pinellas County Property Appraiser and Tax Collectors Database. Madam Chairman, if you would please accept all the exhibits into the record as evidence. The initial inspection on this property started on October 3rd, 2017. It's a white Cadillac and a red Chevy in the driveway. The Cadillac had no tags and does not appear to be operative. The red Chevy had expired tags. I left a door hanger initially with 10 days to comply. On October 14th, the Cadillac had current tags. The red Chevy's now under a cover, which is not allowed under the code. Sent a notice of violation at that time, and it was sent via certified mail and first class. Return receipt requested. On November 1st, I conducted a reinspection. The car cover on one vehicle, as I stated, so it still wasn't in compliance at that time. On November 2nd, the final NOV was mailed certified mail and first class return receipt. On October 18th, I conducted another reinspection. I don't briefly touch on this, but it's not for the board to consider because this is another case that is up to be established. It's currently in compliance. There was a fence added, so I had to do another amended NOV and some things for a fence, but that fence has been taken care of. So that occurred on November 18th. On November 20th, the final notice of violation was mailed, certified, return receipt, in first class. I conducted another reinspection December 9th. The inoperative vehicle was still on the property. At that point, I sent a notice of violation for January's code board. December 11th, the notice of hearing was mailed first class and return receipt. On December 29th, I posted the property and the affidavit of posting was signed. January 10th, I conducted a final inspection. It's in compliance. The vehicle that's under the car cover is operable and has current tags. All of my certified mail was returned unsigned. I actually haven't had any contact with Sarah, but I've been in contact with, I assume, your significant other via email, and most of the issues were taken care of via email. The only thing that's before the board right now for them to consider is a 40.00, which is the vehicle, and have them established for any future violations of having inoperable vehicles or unregistered vehicles on the property. And I have nothing further at this time.
Board have any questions for Officer Gaston? You have any questions for Officer Gaston?
I would really like to not be put on as a repeat offender because a lot of it was, I believe, a misunderstanding. The red car was gone after pretty much the second request. It was the 65 Impala that was.
I'm sorry, but I can't hear a word you're saying.
Me neither.
Oh, I'm really short. Can you hear me now? The red car was gone pretty much after this second request. That was a friend of ours that he was doing a paint job on, and then a 65 Impala was actually brought in, and so that's when he thought it was still the red car. It was not the red car. It was the 65 Impala that was brought in, and then that one was taken back out. And now we actually do have a shop in Clearwater that he's keeping all his cars at, and I don't think it will be a problem. And if the trailer's brought in, it would just literally be for an overnight if he purchases a car, and it'd be for a short stay. So I really don't want to be put in as a repeat offender because we are not repeat offenders. I love Tarpon Springs. I don't want our neighborhood to look trashy. And we were just waiting for the shop to open up. We have a shop now. It's in Clearwater. It should not be a problem. And I would hate get a ticket just for something silly, since now we shouldn't have any more problems. The fence was put up to try to like remedy this solution, and it was a misunderstanding with that too. We didn't know that we couldn't, do that. And obviously he contacted you, fixed it. Everything we've really tried to fix. As soon as he's had a problem with you, he's talked to you, he's tried to fix it. We've gotten our cars tagged. Obviously cars are his hobby. Like I said, we moved here to raise our kids here. We love it. And that's pretty much it. We are not repeat offenders. Everything should be fixed from here on out.
All right, since you didn't have any questions, we just let you go ahead with yourself.
I'm like,
Does the board have any questions for Ms. Stillman?
I do not have this listed as a repeat offender,
It's not. She's just to be established. She's in compliance with everything.
establishing the violation. If it occurs again, then we would consider that a repeat. This is just kind of like your big warning.
okay, yeah, I just didn't want to get a ticket if, something should happen again, because that'd be terrible. Sometimes we would have the trailer if we're going on a camp trip, just like pulled in to go camping. I didn't want to get a ticket if that was the case.
Okay. Officer Gasson, do you have any questions?
I do not have any questions. Thank you.
Would you like to summarize?
I think we covered it.
Okay. Do you have anything else you'd like to say?
No.
We'll close the public portion of this case. I'd like to entertain a motion for established. Is that what we're doing?
Yes.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, section 14-00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Correct the motion to stipulate that it's city code 40.00, is that correct?
You had said in your motion 14.00, and I think what you meant to say is 40.00.
00.
Yeah, okay, and that's what everybody wanted to make sure that they all understood. Okay.
Thank you.
All right. We have a second?
I second.
Any discussion? We have a roll call?
Mr. Robertson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes. Did you roll call? So it's just to let her know that it's fine. I don't know.
Yeah. So I can do that. So Ms. Stillman, I'm just going to summarize what's happened here. The board has found that you had been in violation of the code 40.00 in the past. If you were in fact found to be in violation of 40.00 again at any time within the next 5 years, it's going to be considered a repeat violation. It's very, very important that you don't allow any inoperable or unlicensed cars out there on that property to make that a violation again. The reason being is there's a fine up to $500 a day for each day that exists. So you just need to be vigilant that I make sure that it doesn't happen any further. But there's no fine as of today. So, okay.
So how could so if there was, say he considers it inoperable, but is indeed not inoperable, how could they come to like?
You can talk to the code enforcement department and Officer Gasson as to what's operable and inoperable at the time. My suggestion to you is don't ever get to that point where you have to ask that question. Okay?
I would just be afraid there'd be like a miss.
Yeah, they'll have the opportunity to talk to you about it. If you dispute what they're saying, you'll have that opportunity to come back before this code enforcement board and present your case in the repeat violator. Okay?
So they can't give you a ticket the first time.
It's not a ticket. It is a notice of violation, but you just cannot have this violation again within a 5-year period of time.
Because like he has this.
He can answer all your questions after the board meeting. We got other cases that we need to go ahead and handle.
Nervous. I don't want to get. I'm like I don't want to get any.
Okay, so you can talk to Officer Gasson after the meeting, or call him tomorrow whenever you have time. He'll be able to help you out.
Cars aren't my thing. They're his thing. My car
Okay.
works perfect.
Okay.
Thank you.
Thank you very much.
Thank you.
Okay, our next item, 17-800000610 for 1673 Seabreeze, Wells Fargo Bank. Is there someone here? Give your name, please.
Yes, Your Honor. Name is Albert Zakarian, Zakarian, appearing as an attorney on behalf of the current property owner, Wells Fargo Bank. As an initial matter, I do not object to the entry of any of the exhibits from Mr. Gasson, and nor do I object to his rendition of the facts as he may present them.
Thank you. That's helpful.
And you'll receive those into evidence then? Return them?
Yes, ma'am.
Thank you. Case number 17-8000610, property address 1673 Seabreeze Drive. I have 4 exhibits, as noted in the previous cases. My photographs, including my inspections, are exhibit number 1. Exhibit number 2 are my notices, including the notice of violation and notice of hearing. Exhibit number 3, administrative docs, case summary, property appraiser and tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All of the photographs and exhibits were presented to the violator, exact copies of mine that are being presented to the board. And all of my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collectors Database. And please accept all these, and the record is evidence, Madam Chairman.
Yeah.
The initial inspection on this property was October 12th. There was some significant damage to this property after the hurricane, presumably because the garage door was okay prior to the hurricane, so we all kind of guessed it was the hurricane. As you can see in the photographs that are going around, there's some significant, basically the whole garage door on this, it's a rather large garage door, kind of just caved in. There were some issues with the soffit and a couple other things structurally with it. We sent notice of violation on October 16th, conducted a reinspection. There was no change on November 1st. On November 3rd, the final NOV was mailed with certified mail and first class return receipt. I conducted another reinspection on October 18th. We've been in conversation with numerous people regarding this property. And it sounds like largely because it's a bank, they have to go to bids, and there's some things like that. And there's also some ownership change possibly progressing as once we're dealt with this. So long story short, we received some emails. I did the notice of hearing, was mailed on November 20th, conducted a reinspection December 27th. Still not in compliance, but as I stated, we've had some emails back and forth with the property. Final inspection, I posted the sign on December 29th. On January 10th, it still wasn't in compliance. We had received a letter from the folks. It was January 3rd, and we had already started the notice of hearing process. The long and short of it, as the attorney stated, he had no objections to it. They basically wanted some more time to just finish it up and bring it into compliance. I brought it before the board just in case something else happens to it, so that it could still be dealt with, and in a timely manner the board could address that. So we can discuss that after any motions as far as time frame goes. And that's all I have at this time.
Okay. Does the board have any questions for Officer Gasson? Do you have any questions for Officer
No.
Gasson? Would you like to give your case?
As I said earlier, I don't disagree with Officer Gasson's rendition of the facts. I have no objection to the establishment of the violation upon his inspection, so the board can get through that part of it. Officer Gasson's correct. On January 3rd, we did email and send a letter to the board requesting an extension. You'll see Officer Gasson was kind enough to include in Exhibit 3 that he provided to the board the email, the letter, and attached to the letter were bid summaries that we had put out in order to get the work done on the property, because as we are the owners of the property, Wells Fargo Bank, we can't sell it ourselves, which we intend to do, until it's in compliance. So we have as much motivation to do so as the city would to have it be in compliance. What we're looking at right now, as it explained in the letter, is we're waiting for the labor and materials and obviously the insurance company to approve the bid so that we can get the work done. We're simply requesting a 45-day extension of that time in order to get all of that together and get the work done and up to compliance. I discussed this with Officer Gasson. I don't know how he feels about it right now.
Yeah, we discussed, I have no objection to 45 days either, so we just presented to the board.
Okay, does the board have any questions? Go ahead.
One of the documents that you submitted said you expect this property to close on January 15th.
That was something at that time we were thinking about, and I know he hasn't been sworn, but there's also a listing agent here who appeared on behalf of one of the bank's vendors that would be working what the bank calls REO. Essentially, that means that they're going to take the property and sell it. That can't be accomplished at this time because we need to make sure it's brought up to compliance first. We were hoping it was going to be by the 15th.
So do we have a pending contract on the property that says when this is fixed, the sale's going to take place?
Before I allow him to testify,
You have
I know
to be
Mr.
sworn
Trask
in.
may want him to be sworn.
Yes.
Sir, were you sworn? Okay.
Okay, I didn't see you. Go ahead. Is there a pending contract?
Sir, if you
Yes.
can give us your name, please, and your place of business.
My name is Derek Golden. I am a realtor, the listing agent. My brokerage is Allison James Estates and Homes. This property is under contract. There has been many attempts to reach settlement. However, due to the complications of the damages caused by Hurricane Irma, settlement has been delayed multiple times. The current settlement date is scheduled for the 15th. However, there are some delays due to the breakaway wall and garage door. It is oversized on special order. You will see some of, and I'll go ahead and leave it at that.
Okay. Anybody have any questions? More questions?
Yeah.
Yes.
You said 45 days?
Yes, Your Honor, that's what we're requesting.
March 1st, okay?
I'm sorry, what was the question?
March 1st?
That would be fantastic.
Hmm?
That would be appreciated, yes.
I have a question. You're the realtor. Did the potential buyer agree to an extension of the contract?
The buyer has agreed to many extensions of the contract. The buyer is well aware of the violations. The buyer has retained legal counsel who is also well aware of the violations. Any correspondences that have transpired between the seller, the board, code enforcement have all been included, and the buyer is well aware of the situation.
So he'll extend past March 1st then?
Yes, the buyer's been hanging in there. Original settlement was scheduled for September 13th. Hurricane Irma hit on September 11th, and we have been extending the settlement deadline.
So he hasn't agreed to an extension yet?
He
Past
has
March
agreed
1st.
to multiple extensions. Currently, the extension in place is until January 15th. We're waiting until the outcome of today's hearing to implement another extension.
Has he implied that he's going to extend it?
Yes, he sure has.
Good question.
Anything else? Officer Gaston, do you have any questions?
I do not.
Questions? Would you like to summarize?
I think we covered it.
Do you have anything else you'd like to?
No.
Okay. We'll close this part of the public portion of the hearing, and we'll entertain a motion.
I move based on the testimony, evidence, and facts presented in the law that at the time of the alleged violation, Section 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was and is in violation thereof.
Second.
Is there any discussion? Okay, may I have a roll
These-
call? Oh, go ahead.
My experience with banks is that they continuously extend things. And my concern is that this violation be done within 45 days, whether they settle or not.
It seems like a long time when we have contracts outstanding to get the work done.
Yeah, I agree with that, too. I don't think our business has anything to do with whether there's a contract or not. I think it was a good question
Yeah.
by Tim, but I don't think it has anything to do with that.
Okay, great.
Yeah.
Okay, roll call.
That's the real estate guy nervous about whether he has a contract or not, and Wells Fargo nervous about that.
Clarify the motion for me. What's the motion for?
The motion right now is to find the property in violation of Section 8-40, duty maintenance of private property.
Yes.
It's a two-part motion.
Ms. Norfleet?
Yes.
Yeah. Ms.
Hold
Norfleet
on a
says
second.
You're in the meeting.
Yeah, she came to the meeting late?
She came into this item, sir.
Right, so we're not going to allow that vote to take place, and so I don't want you to call on that.
Okay, sorry.
Just make a note that on the agenda that she appeared at 2:58 PM, which was 3/4 of the way through the case.
Okay.
And I just don't want there to open up a possible appeal for her voting on this decision and because of the fact that it was so late in the game, so.
Will she vote next time? On the
Yes,
next,
yes,
agenda?
on all the
Very
other
good.
cases, yes.
All righty. Let's try again, please. Mr. Robinson?
Yes, again.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
And Mrs. Archer?
Yes. Officer Gaston, do you have a recommendation for timeframe and?
Well, I
daily
think based
fine?
on all the testimony we've heard, March 1st of 2018, and based on the significant, I mean, there's some pretty significant damage, and also just to motivate them, probably $100 a day.
Do you have any input
No,
on this?
other than we would like that extension that was suggested by Officer Gaston.
Yes, okay. So we'll entertain a motion?
I move that the respondent shall have until March 1st to bring the property into compliance with code sections 8-40 or suffer a fine of $100 a day for each day thereafter that the respondent remain in violation of said code section.
Second.
Okay, is there any discussion?
Exactly what I wrote.
Roll call.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
So you are aware that you have until March 1st to bring
Yes.
everything up into compliance or suffer $100 a day?
Sure.
Okay. And an order will be issued within 10 days and will be mailed
Thank you, Your
to
Honor.
you. Thank you. Next case, 17-800000624 at 311 Hope Street, Anthony and Nicholas Kruskus. Are they here? Is anyone here?
Case number 17-800000624. The address is 311 Hope Street, Anthony and Nicholas Kruskus. As I have 4 exhibits. Exhibit number 1 are all my photographs, including my inspection. Exhibit number 2 are all my notices, NOVs and NOHs. Exhibit number 3 is the administrative docs to include my case summary, property appraiser, and tax collector's database, and any officer emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All of my notices were mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector's database. Madam Chairman, please accept all my exhibits into the record as evidence.
Yes. Bobby?
Yes, ma'am.
This case started out on October 19th of 2017. I was conducting an inspection on a neighboring property when I noticed violations of this property, which were a significantly overgrown yard. The front and the rear yard are overgrown and need a maintenance. I left a door hanger initially with 10 days to comply. On November 1st, I conducted a reinspection and found there was no change to the property. On November 2nd, a notice of violation was mailed, certified mail, return receipt requested, as well as first class. On November 18th, I conducted another reinspection, and there was no change. And at that point, we also sent a final notice of violation via certified mail and first-class mail on the 20th of November. December 13th, there was no change, so at this point in time, it was referred to notice of hearing, which was sent on the 13th of December, first class, and return receipt requested. I posted the property on December 29th and signed an affidavit of posting. Conducted my final inspection yesterday, and the property is still not in compliance. All of the documents were returned unsigned, marked vacant. I've had zero contact with the owner or anyone representing the property. It almost appears that it is occupied. When I went and put the door hanger up, there was furniture inside of it. But on every contact, there's never been anybody there, and I have no other information as far as if there is somebody living there or not. To the point where there's no newspapers out front, there's no mail, So that's why I say it appears that it may be occupied. So at this point in time, I'd like the board to consider current violations of 8-40, which is failure to maintain private property, and 8-52, which is the nuisance prohibitions, which mainly are covering lot maintenance, mowing, trimming, and edging. And that's all I have for the board at this time.
Does the board have any questions for Officer Gass?
I do. I haven't seen the documents yet. Is the property homesteaded?
I didn't look at that. I'm sorry. I probably could, though. I don't have it. It's going to come around to you. There should be a copy of the property appraiser's website.
Mr. Weeks, do you see that document? You know where, how far
Probably
back
be in
down to
exhibit
go?
number 3.
No.
It is not homesteaded, 0%.
Mm-hmm.
Non-homesteaded.
Okay. So we're gonna assume it's a rental property if someone is living. Can't make that up. Officer Gaskin, it does say it's non-homesteaded and it does appear to be occupied, so we assume it's a rental property? We don't have any basis
I have
for
no inclination one way
Okay.
or the other.
Thank you.
Mm-hmm.
Okay, Officer Gaston, is there anything else you'd like to summarize?
No, ma'am, I think we covered it.
I'll close the public portion of this and entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Okay, roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Stabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes. Officer Gaston, do you have a recommendation for time frame or?
Yes, I would recommend January 30th. This started out October 19th. We did a final NOV, door hangers, notice of violation, so we've given them a fair amount of time. So I would like to request January 30th and $50 a day.
I move that the respondent shall have until January 30th to bring the property into compliance with code sections 8-40 and 8-52, or suffer a fine of $50 per day for each day thereafter the respondents remain in violation of said code sections.
Second.
Any discussion? Okay, roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Stabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
Okay. Next item is 17-800000631 at 27 East Athens Street. John Corfitis. Is there anyone here for this?
Can you give us just 1 second,
Sure.
You're really good with the Greek names.
Oh,
All right, ma'am, I'm sorry.
go ahead.
Thank you. Case number 17-800000631, 27 East Athens Street. Property owner listed as John Corfiatis. There's going to be 4 exhibits as usual. Exhibit number 1 are all my photographs, including the inspections. Exhibit number 2, my notices, notice violation, notice hearings. Exhibit number 3 are my administrative docs to include the case summary, property appraiser, and tax collector's websites. And there's not any officer emails because I've had no contact with anybody. Exhibit number 4 is the affidavit of posting a copy of the sign. All of my notices were mailed to the property owner of record via the Pinellas County Property Appraiser and Tax Collectors database. And Madam Chairman, please accept all my exhibits as evidence into the record.
Bobby, you accept those?
Yes, ma'am.
October 21st of 2017, I was in both a complaint, and I was also inspecting another property. The property was overgrown at the time, and the building is in extremely poor condition. Numerous windows were broken out all around it. The rear door was open, so the building wasn't secured. And the building is leaning to the north. You can just tell that it's listing, for lack of a better term, and it does not appear to be unfit, or it appears to be unfit for human habitation, and it's in significant structural decline. On October 26th of 2017, we mailed a notice of violation via certified mail, a return receipt requested, as well as first class. And on November 11th, I conducted a reinspection. The lot had been mowed, but it appears some more windows were broken, and the building was still unsecure, and the front door now was open and unsecure. I did not go inside the building I just didn't. It wasn't structurally sound. I didn't feel comfortable going inside of it. On December 9th of 2017, the lot had been mowed. There's still some debris, down trees, and obviously the structure hadn't been touched. It's still unsecured and is an attractive hazard. The structure appears unstable, uninhabitable, and dilapidated. On December 11th, notice of hearing was mailed first class and certified mail return receipt. On December 29th, I posted the property and signed an affidavit of posting. And I conducted a final inspection yesterday. And the house is still there, and it's still barely standing, and it does not appear fit for human habitation. And it's in extremely poor condition, but the lawn is mowed.
You did get the green cards back signed?
My notice of violation and final notice of violation, green cards were returned signed, addressed to owner.
Wow.
So, but I again have had no contact with anybody representing this property whatsoever. So today before the board, I'm only presenting the violation of 8-40, which is a duty of maintenance of private property, which includes a couple of sub-ordinances, which is the requirement that you can't have a dilapidated structure or a structure that's unfit for human habitation, as that's a nuisance. And that, as all I have, as you guys can see when the pictures go around, I think I was fairly able to represent the northern side of the building. Looking at it to the west, you can actually see it's probably 4 or 5 degrees of angle to that side of the building. So even if it does fall, the only positive thing is there's another building farther away than the height of the building. So if it does fall, it's not going to affect the occupied house next door. But we don't know if people are using it as a temporary residence, if you will, and what else is going on inside of the property.
Do you think that's happening?
I'm sorry?
Temporary residence, you think it's happening?
Yeah.
Okay.
And this is the first time we've cited them?
Well, there were prior cases, and I didn't get into the notes of them in 13, 10, and 9. But like I said, I didn't get into the notes of what was actually about them. But as you can appreciate, an unoccupied structure, nobody living in it can go into decline fairly quickly, especially an older one. I imagine this house is probably 40s or was built probably prior to 1940. It's one of the older structures in town.
Yep.
But that's just a guess, so.
Okay, is there anything else?
No, ma'am, I don't. Thank you.
Okay, so we'll close the public portion. Should I wait for? I entertain a motion?
I move, based on the testimony, evidence, and facts presented in the law, that at the time of the alleged violation, sections 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second?
Second.
Do I have a second?
Second.
Any discussion? Okay, we'll have a roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Stabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
Dr. Gasson, any recommendations for time frame or?
Yes, ma'am. As I stated, and I think I kind of covered in my testimony, I believe the property is an attractive hazard, needs to be dealt with fairly rapidly. We started the case out October 21st, so they've had some time. They're obviously getting notices, otherwise they wouldn't mow the yard. And at that point, I'd like to request the board basically give them 14 days, which would be January 23rd, and a fine of $150 a day.
I move that the respondent shall have until, what did he say, January 30th?
23rd, he said. He said January 23rd, if you want to go with that.
30th,
30th.
to bring the property into compliance with Code Section 8-40, or suffer a fine of $150 per day for each day thereafter the respondents remain in violation of said code.
Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
Madam Chairman, we're going to change the order just a little bit because we have some people here. The case number 9, which is 204 Lakeview, and number 10, which is also a vacant lot on Lakeview, we're going to push those out towards the end if you don't mind, because nobody's here for them.
All right.
Which would put us going forward with 106 East Lime Street, which the gentleman's walking up right now.
Item 12.
We're going to hear yours. Thank you, ma'am.
Okay, this next case is a repeat violator. Item 17-800000704 at 106 East Lime Street. Paul and Tina Bakalakapula.
Bakalapalo, that's close enough.
Okay, would you give your name, please?
Paul Bakalapalo.
And you are the owner?
Yes, ma'am. Did he see the exhibits?
Were you sworn in?
I was.
Do you have any objections to the city's documents or photographs being
No, I don't have
received
any
in
objections.
evidence?
I do not have any objections to Officer Gasson's.
Okay. Officer Gasson?
Thank you. This is case 17-800000704, 106 East Lime Street, Paulentina Bakalopoulos. They've been out of compliance. It's a repeat violator case referencing back to case number 17-2 for codes 8-22, 8-40, and 8-52. I initially conducted let me take care of my exhibits first. Exhibit number 1 are all of my photographs to include the inspections. Exhibit number 2, my notices, including the repeat violator notice of hearing. And exhibit number 3 are administrative documentation, emails, property appraiser and tax collector records. Exhibit number 4 is the affidavit posting a copy of the sign. And exhibit number 5 is the prosecution costs regarding this case. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collectors databases. And Madam Chairman, if you would please accept all these exhibits into the record as evidence. This case started, as I was stating earlier, November 17th was when I conducted the initial inspection. The 100 block of Lime Street I've had numerous complaints on, and I specifically was looking at a property across the street, which was the complaint, and I observed violations on 106 East Lime Street. It's an unoccupied structure. It's a double lot. Unfortunately, the eastern side of where the structure is seems to be the local dumping ground for a large amount of trash and debris. It's an ongoing problem that Paul's having. He's given trespass authorization to the city. Unfortunately, we're just unable to catch anybody in the act of doing it, but he does continue to suffer. I definitely don't want to call it the benefits, but unfortunately, they're using his property significantly to dump on. And that was the nature of the complaint. He had a prior complaint, as I stated earlier, in 2017, where the property was established for those basic violations. The lot was covered in trash and debris. And the shed on the rear property is in poor condition. We had some discussion about the boarding up of the windows, and I had actually recommended he do that to try to keep the transient population from occupying the structure. Unfortunately for him, he still has people tearing off the boarding up on the property in that area. November 17th, the repeat violator notice of hearing was mailed first class and certified mail. December 29th, I posted the property. We did get back the NOH signed, and obviously Paul's here, so he's aware of it. And so at this point in time before the board, as I stated, is a repeat violator for sections 8-22, which is accumulation of trash, 8-40, the duty and maintenance of private property, and the nuisance prohibitions for just maintaining the lawn itself. And that's all I have at this time.
Okay.
And as I did state, it's been since November 17th and it's still currently not in compliance.
Board have any questions for Officer Gasson? Sir, would you have any questions for Officer Gasson? Just questions at this time?
No questions. He's
Okay.
pretty thorough.
Would you like to go ahead and,
Well, I mean, as Officers Gasson had mentioned, it's definitely been a trouble spot for myself through the years, even prior to Officer Gasson's involvement. I've owned the property probably over 10 years, and our intentions initially was to put our office there. We started reconstructing the structure, bringing it up to code and everything, went through, resecuring structurally, and then the market, of course, fell. And then the neighborhood fell. I mean, we've been fighting, people living in the home constantly. We've kicked people out. We've called the police. We've had constant dumping on the site. So this is the first time I've been in front of the board. We've always been in compliant. We've been noticed. We've gotten it compliant several times. And, I'm just, I guess, requesting leniency at this point. We will clean it up. We'll bring it back into compliance. But it's just been an ongoing battle on that street. There's probably never a time that we go by there and that we're kicking somebody out of the house, and they're breaking into the house and they're dumping stuff there. And I think there's some local person that's in the garbage business and has created a dump site on our site. We will bring it into compliance, and I'm just requesting leniency from the board, and we hope to bring that building and maybe put our office there eventually. I mean, I've been in the area since 1980, and I'm actually a general contractor, so I'm planning on staying. So that's about it. Mr. Officer Gasson's been more than cooperative with us and leaning with us through the years, and that's about it.
does the board have any questions?
You live here in town and you drive past this property every day?
Actually, no, I don't. I live in Clearwater.
And you have maintenance people that are supposed to keep this property up?
We recently, prior to, or actually just after he noticed us, is when we went back out there. It must have accumulated just recently on the site. Someone must have just, oh yeah. It's been, I mean, the last time when we went to compliance, we pulled out 2 30-yard dumpster loads. I spent thousands of dollars to remove debris. And then I guess probably over the past couple of months, it's accumulated again. So, it's I understand it's an eyesore to the city, and we're definitely willing to bring it into compliance.
Sounds like you have a real problem.
Well, I wish the street would have done what I thought it was going to do. I mean, they rezoned it to more of a general use for businesses, and I don't know. I mean, Steve can tell you it's been it's a tough street, and I wish it wasn't. It's so close to the downtown apartment. So we'd like to be part of the redevelopment if we could,
Officer Gasson, do you have any questions?
I do not have any questions.
Okay. You would like to summarize?
I think we've covered it.
Do you have anything else you'd like to say?
No, I think
Okay.
that's covered it. Yeah.
Okay, we'll close the public portion of this. I'd like to entertain a motion.
Can I get an understanding of what the other fine was?
I'm sorry?
Previous fine was $500 a day, is that what the paper said?
Ooh, he was simply established. He's never been before the board. He's always been extremely cooperative. I think there was also a little bit of misunderstanding, although it is what it is. Because I got an email, I believe, from Joan, who's from the company, said, can we get some more time just to get somebody to clean out? I don't think they understood that it was a repeat violator and his fines were going daily. I was going to ask the board to be fairly lenient on the fines because I'm sure he will take care of it, but he is about 60 days into it already, so that's already going to be a sizable chunk, whatever the board decides. But I do believe he'll once again invest probably a couple $1,000s to clean it up because that's probably what it's going to take, and we're going to and then he'll get the idea that we really got to, unfortunately, babysit this property.
And I'd like to add one more thing if I could. okay? I mean, Officer Gasson suggested we put a fence up, and he's not the only one. The prior code enforcement people asked us to do that as well, and we did do that, and then the fence was driven over and knocked down. I mean, and we're willing to do whatever Officer Gasson suggests that we do to reduce the impact until we do redevelop the site. But we've tried everything, and again, I'm open to any suggestion, because it's the people living in there is the concern. I mean, the structure is not unsafe, but they're making it unsightly.
Gonna be.
Yeah, but we've given the police department full authority to step on site and arrest anybody that does step on site. So I don't know where these people are going to go. I mean, we've had up to like 8 people living in that home. Yeah. So I wish I could charge them rent, or maybe they could have cleaned up after stuff.
I just am unclear because there wasn't a fine established in that earlier finding.
No, there wasn't, because he was in compliance, and I was just strictly bringing it to bring it to be established. So there was no previous fine ever discussed.
Maybe I misread it.
It's okay.
I know
Yes,
you
that's
read
correct,
it
so.
1,000 times and I just misread it.
It's just with repeat violators, it can be up to $500 a day. That's all. But there was never one
I
established.
think I
Yeah.
scanned it and that's what I saw. Thank you.
If I'm given maybe 30 days to bring it into compliance, we'll probably have it done in less than that much time, of course. But we'll get on it immediately, like we discussed with Officer Gaston through email.
Ask him. Do you have a recommendation, Officer Gadd?
I would, like I said, he's already 60 days into it. $10 a day already puts him in the neighborhood of $600 for a fine. And I think, he's going to get it done, but that would just be my recommendation. It's also his first time. He's here, he's trying. So I do think for that matter, like $10 a day for what he's already incurred is reasonable.
How long you giving him?
There's no compliance date. He's already in violation.
He's a repeat violator.
Yeah.
I couldn't hear you.
There's no compliance date. He's already in violation. It's a repeat violation. So the fine would begin on the date of the first inspection.
Yeah.
Which, according to the testimony you received, is November 17.
Okay, so we need a motion on that.
I move that based on the testimony, evidence, facts presented, and law, that Paul Bacalapolo was in violation of sections 8-22, 8-40, 8-52 of the City of Tarpon Springs Code from November 17th until such time as the property is brought into compliance, and a fine of $10 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $61.50 for the costs incurred in prosecuting the case.
Second.
Okay, any discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Motion carries.
So you have
Get somebody out there more often.
given the date of compliance and a daily fine, and an order will be issued and mailed to you within 10 days. Thank you. Hope you can get it taken care of. Yeah.
Give me a call. You call me when you get ready, okay? Sorry, man. We're trying to get folks out of here that are waiting if we can. I know he's here for Denami Holdings. Case on the docket is number 13, which is the vacant lot across from 26 Acacia. Mario will get you next.
Is the address 2 Acacia or is 26 Acacia?
It's across the street. It's a vacant lot. It's a parcel number.
Just we have two different.
It's the number 13 on the agenda. The
2 Acacia on this page.
On one paper it says no,
oh
from across from 2, and on one paper it says 26.
Case 743. That helps.
Right here it says 2 instead of 26.
This one is not right.
It's just a typo. On the
correct?
website.
Okay.
2.
It should have been across from 26.
Yeah, it's
26.
20.
Okay, that's all. I just want to make sure we got our Ayes.
Okay, we have item number 17-800000743. Violation? What is
Yes, it's a repeat violator.
Oh,
vacant lot.
Vacant lot off the,
Oh, sorry, VL, vacant lot.
I know, west, across from 26 Acacia Street, Denami Holding LLC. Is there someone here? There you are, sir. Would you please give your name?
Nick Mavromatis.
And what is your, are you the property owner or?
I'm one of the members of the LLC.
Okay.
There you go. Thanks. Case 17-800000743 is stated. It's a vacant lot across from 26 Acacia Street. The parcel number is 12. Oh, sorry.
Yeah, I'm just asking, do you have any objection to documents or photos being put into evidence?
No.
Thank you.
Sorry.
Bobby, you received those in evidence?
Yes, ma'am.
As I stated, case 17-8000743. The vacant lot across from 26 Acacia Street is parcel number 12-27-15-41202-000-0220. This is a repeat violator case. It was out of compliance from December 9th to December 14th for a total of 5 days. I have 4 exhibits. My photos to include the inspection are exhibit number 1. Exhibit number 2 are all the notices to include the notice of violation and notice of hearing. Exhibit number 3 are my administrative docs, including the case summary, property appraiser, and tax collector's database. And exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of those being presented to the board. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector database. And Madam Chairman, if you would please accept all of these into the record as evidence. Initial inspection started on December 9th. The lot was overgrown, had a dead tree on the western side of the lot near the fence. December 14th, the property was in compliance. December 29th, I posted the property. I did get a green card returned, unsigned, but I have talked to Nick a couple of times, and there were some interesting circumstances behind this property. He has a lawn service take care of it and accidentally mowed the wrong lot. So he was kind enough to mow a neighbor's property instead of his own, and that's what consequently stemmed the violation, which occurred because I was inspecting 26 Acacia Street as the nature of the complaint. So unfortunately, Nick got kind of held up in a he did a really good job mowing the neighbor's yard, but unfortunately his lot wasn't taken care of. So unfortunately, we're here before the board, and he was out of compliance for a period of 5 days. I bring before the board just the repeat violator under 8-52, and it initially stemmed from the repeat violator case was 17-482, which was a violation of 8-40 and 852. So, and as I stated, he is in compliance as we speak.
Does the board have any questions for Officer Gasson? Sir, do you have any questions for Officer Gasson?
No, I don't.
Would you like to present your case now?
Yes, as Officer Gasson said, we actually own the lot right next door to it, and the one was mowed, but they mowed the one that we owned and somebody else's lot instead of the one that got the violation. So it was an oversight. And I didn't, the last time, as far as the repeat offender situation is concerned, the last time I appeared here, I was told about the repeat offender, but I thought it was per property, not like whatever you own in your name. But as Officer Gasson can testify, I was trying to be in compliance ahead of time by getting them mowed, but they mowed the wrong one. I didn't even know about the other one not being mowed until I got the notice. And then I said, well, we just mowed them. And no, I said, so that's what happened.
Okay. Does the board have any questions for the gentleman?
Do you live in town?
Yes.
Officer Gasson, do you have any questions?
I do not have any questions, ma'am. Thank you.
Okay. Would you like to summarize?
I think we're good.
Do you have anything else you'd like to add, sir?
No.
Okay, we'll close the public portion of this and entertain a motion.
I'm unclear as to what fines were established initially.
That's what we're here for. So none were, he was established on another property that was in compliance. And then as we stated, and if the board was to ask me a recommendation, I would throw out basically the same as with Paul, would be $10 a day. This was an oversight on his, it wasn't even necessarily his fault, other than his landscaper might need some retraining, but it's beyond the point.
I have a question.
Sure.
So we would be fining him whatever a day for 5 days.
For 5 days.
Because of an oversight, but he finally mowed the property.
But he is still the owner and still responsible.
Right.
So yes, ultimately that's true.
And it's the one, he's in compliance now.
Oh, he is absolutely, yes.
Okay.
He did it as fast as he could.
You want to make a motion?
I move based on the testimony, evidence, and facts presented in the law that the respondent was in violation of Section 8-52 Tarpon Springs City Code from
December 9th, December 14th, 5 days.
December 9th to December 14th, 5 days. A fine of $5 a day for the days, or a total fine of $25. In addition, I move that the city be awarded $0 for cost incurred prosecuting.
No prosecution?
No. Need a second?
Second.
Any discussion? A roll call, please.
Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Dabbs,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
Your motion carries.
All set?
Yes, sir.
Thank you.
He's going next.
14?
Yes, ma'am. Please.
Item number 17-8000750, vacant lot across from 801 Sunset. Mario.
Jamarca.
And are you the owner of the property?
Yes, I am.
The exhibits.
I keep forgetting those. Do you have any objections to documents or exhibits being
No, I
put
do
in
not.
for? Bobby, if you accept the exhibit into,
Excuse me?
I was talking to the clerk.
Ready? This is case number 17-800000750. It is a vacant lot across from 801 Sunset. It's parcel number 11-27-15-87786-016-030. It's a repeat violator case stemming from case number 16-269 on the same property for 822, 840, 852, and 12-1. Those were the violations at that time. The property was out of compliance from December 9th to December 22nd for a total of 13 days. It is currently in compliance. The exhibits going before the board are exhibit number 1, all my photographs to include the inspections. All my notices to include the notice of the repeat notice of hearing is exhibit number 2. Exhibit number 3 are my administrative docs, including any emails, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is prosecution costs. All the photographs and exhibits that were given to the violator are an exact copy of what was being presented to the board. And all of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector. And Madam Chairman, I think you've already stated, but please accept these into the record as evidence. Case started from a citizen complaint on December 9th of 2017. It had debris on it from a fallen tree. As you can see in the photographs that were going around, because of Hurricane Irma, a large tree had fallen on the lot, and there was a large pile of tree debris. The notice of hearing repeat violator was mailed certified mail in first class to the owner on December 11th. On December 22nd, the owner left a message, made an office visit, stating the property was ready for reinspection, which I did conduct on the 22nd, and it was in compliance at that time. Posted the property on December 29th, and none of the mail was returned to us. And as I stated, I have had contact with the owner, and he's present today. Basically, As I stated, he was a repeat violator for a period of 13 days of Code Section 8-40 and 8-52, and that's what the board is here to hear. And I have nothing further at this time.
The board have any questions for Officer Gasson? Sir, do you have any questions for Officer Gasson?
No, I don't.
Would you like to give your?
Well, I would like to add is that we submit the permit, the application for the permit to fix the sidewalk today, so I'm gonna wait until they approve it and get the job done about the sidewalk.
If it helps the board, I didn't bring it up. His crew that took the tree down or cleaned it up, they broke the city sidewalk. So he also now has to pay to repair the city sidewalk. I didn't bring it before the board as a case, but that's what he's talking about when he's talking about the permit, just so you guys understand.
Does the board have any questions, gentlemen?
The previous, this is a repeat violator. What were the same issues? I know the tree wasn't down before, but
It was debris on the property, maintenance of the property. And yes, because the tree went down, it became debris on the property and maintenance of the property. And on the previous case, it was just established. There was no fine because he was in compliance. So
Only
he was
was
just established. Yes.
and am I not finding the date that
The time period? The time period was from December 9th to December 22nd for a total of 13 days.
I mean, from the original?
Oh, the original was 2016 case. There was 3 lots that were an issue, and his actually was the fastest to come into compliance. But I established all 3 of them at that time. And he's been good about taking care of it, more so out of all the lots.
Thank you.
Do you have anything else?
I do not. And I have no further statements either.
So we'll close the public portion. Entertain a motion.
I'll make a motion. I move that based on the testimony, evidence, facts presented in law, that the respondent was in violation of section section of City Code 8-40 and 8-52 from the date of the initial inspection, which was 12/9/17, to the compliance date of 12/22/17, and a fine of $5 per day for 13 days, or a total fine of $65. In addition, I move the city be awarded $61.50 for the costs incurred in prosecuting the case.
Second.
All right, any discussion? A roll call, please.
Ms. Northfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs? Yes. Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Your motion carries.
So that's it, sir.
You want me to summarize for you?
Yes.
Sir, you've been found in violation of Code Sections 8-40 and 8-52 for the time period of December 9th through December 22nd. A total of 13 days. You've been fined $5 a day for a total of $65 for the fine. In addition to that, there are prosecution costs that have been awarded. So your total fine is going to be $126.50. You can pay that at the clerk's office. It'll be about 10 days before you get the order from the clerk, though. So you may want to get that order in hand before you go back to pay that fine. All right, thank you.
Thank you, sir. Where are we
We'll
going
go
now?
back now, if you don't mind, to the 2 cases we set aside, 9 and 10, 639 and 641, if you don't mind.
Nine.
And there's nobody here for
Number
either of
9?
them. 639, which is number 9, 204 Lakeview Drive.
Yes, item number 17-800000639, 204 Lakeview Drive by Bel Air Reserve Holdings, James Anderson, R.A. Is there anyone here? No.
Thank you, ma'am. Case 17-8000639, 204 Lakeview Drive is the address. It is a vacant lot. Parcel number 17-27-16-31356-002-0020. owned by an LLC referred to as Bel Air Reserve Holdings. There will be 4 exhibits going before the board. Exhibit number 1 are the photographs of the vacant lot. Exhibit number 2 are all my notices to include notice of violation and notice of hearing. Exhibit number 3 are my administrative docs, case summary, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign. All of my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collectors Database. And, Madam Chairman, please accept all my exhibits into the record as evidence.
Yes.
Case started out on October 25th of 2017. This lot is less than 10,000 square feet and needs to be mowed, and the debris needs to be cleaned up. The lot was overgrown with debris on it. The lot is adjoined by another vacant lot with the same owner, which happens to be the next case we'll be talking about. On November 25th, the notice of violation was mailed, certified mail, return receipt requested, as well as first class. This property has a downed tree on it, which was the result of the debris for it. And it's right next to a residence. So the debris that I inspected on October 25th was the large tree, and you can see in the photographs how the pictures, because of where the property is, I'm kind of showing you a long view of the tree, but it's a significant, I think it's a pine tree, and it's probably about 40 feet long, and it's partially uprooted on the western end. You're looking at the eastern end of the tree, and unfortunately you can't really tell how long it is, but I couldn't get you a better perspective because there's another piece of property there. Moving forward on December 18th, the notice of violation was mailed, certified mail, return receipt, and first class. October 29th, I posted the property. I conducted a final inspection on the property yesterday. It was not in compliance, and the tree was still on the property. Mail that was returned was the NOV was returned unsigned. The final notice of violation and the notice of hearing were returned signed. I've had some email contact with a representative, Tori Cooper, from the company. He stated we gave him some extensions because post-storm, his tree crew was in Texas and some other things, so we kind of extended. That's what the final notice of violation was for. He had an email exchange with me this past week that he was going to have it cleaned up again. And unfortunately, the tree still remains. And there was another little bit of debris on the next property that we'll talk about. He was able to on a third property, and it's not relevant to this case, but just so the board understands, he had a much more significant amount of tree debris that was able to be cleaned up on a case that's in compliance, not before the board. So I'm just a little confused on the time thing. So I decided to go ahead and bring the case before the board and let this body decide how to handle it best. But that's all I have at this time on this case.
Okay. Any questions for Officer Gasson?
So you're saying he has other properties which he has taken care of and for some reason did not do this one?
Yeah, like I stated, there's been a myriad of, I'm sure he would consider them reasons. I kind of consider them excuses. I think the last one was the vehicle that he needed, couldn't get close enough or something to that effect. It is what it is. So,
What's your guess on what he's gonna do? You know him. What's he gonna?
Oh, I don't know him.
A week or 2 or 3 or?
Well, I think he needs to be influenced. That's just my opinion.
Okay. We entertain a motion?
I move based on the testimony, evidence, and facts presented and law that at the time of the alleged violations, here I go again, the alleged violations of City Code 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? A roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mr. Weeks?
Yeah.
Mrs. Archer?
Yes. Officer Gasson, do you have a recommendation?
I would say 2 weeks, $150 a day.
Yeah.
How much per day? 100?
$150.
Okay. I move that the respondent shall have until January 25th to bring the property into compliance with code sections 8-52 or suffer a fine of $150 per day for each day thereafter the respondents remain in violation of said code sections.
Second.
Any discussion? Roll call, please.
Ms. Norfleet?
Yeah.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Bless you.
And to the next item, which is same 17-800000641, vacant lot at Lakeview Drive, Bel Air Reserve Holdings, LLC.
No one here for it either.
No one's here.
Case number 17-800000641. It's a vacant lot on Lakeview Drive. It's directly next to the previous vacant lot to the north. Bel Air Reserve Holdings LLC is a listed property owner. The case or the parcel number is 17-27-16-31356-002-0010. There'll be 4 exhibits going before the board. Exhibit number 1 are the photographs, including the inspection photographs. Exhibit number 2 are my notices, my NOVs and NOHs. Exhibit number 3, administrative docs, including case summary emails, property appraiser and tax collector records. And affidavit number 4, or exhibit number 4 is the affidavit of posting and a copy of the posted sign. All of my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collector's website. And Madam Chairman, please accept all my exhibits into the record as evidence.
Yes.
This started on October 25th, as I stated earlier with the previous case. At the time, the lot was overgrown and had some debris on it. On October 25th, the notice of violation was mailed, certified mail, return receipt, first class. I conducted a reinspection on November 28th, and it was still not in compliance. November 28th, we gave them a little bit of extra time, sent them a final notice of violation, certified and first class, return receipt requested. December 16th, conducted a reinspection, and the tree debris was still on the property. It's a small amount of debris, as you can see in the photograph. Not even a pickup truck load full, but it's right on the corner across the street from a couple of houses. On December 18th, the notice of hearing was mailed, first class, return receipt requested, and certified. December 29th, I posted the property. On January 10th of 2018, conducted a final inspection, and the small pile of debris is still on the property. As I stated with the previous case, I have had some email contact with him. For whatever reason, he was able to get a large amount of debris off the other property, but not this one. So we are here on that debris on the property. And I have nothing further other than just to ask the board to consider a violation of City Ordinance 8-52.
Any questions?
25th.
Okay, entertain a motion?
I move that based on the testimony, evidence, and facts presented in law, that at the time of the alleged violation, Sections 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondents were in violation thereof.
Yeah. Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes. Do you have any recommendations?
Well, I think we'll just carry on with the same one. January 25th of 2018 and $150 a day fine.
I move that the respondent shall have until January 25th to bring the property into compliance with Code Sections 8-52 or suffer a fine of $150 per day for each day thereafter the respondent remains in violation of said code.
I second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes. Now we'll go to noncompliance. Item number 17-8000486 at 510 Triplet Street, Charles Burrows. Is there anyone here? Oh, boy.
And Madam Chairman, I don't know if there was an affidavit of affidavit of prosecution costs included on the case, and Beth was just telling me she didn't think she had the amount on there. Are you guys
On
aware
there?
of it? Yeah, we do have an affidavit of prosecution costs for $148 to include as well.
148?
148, yes, ma'am.
There should be prosecution costs added to this, is that what you
148.
say?
148.
Okay. So go back.
Okay. You're asking him to give his name? Mr. Burrows, would you please state your name?
No,
Your name, sir?
I am asking for extension.
What they asked.
Charles Edwin Burrows Senior.
Thank you, sir.
And is he the owner of the property?
Do you own that property?
I own the property. Yeah.
Thank you.
It's an affidavit of noncompliance for 510 Triplet. When I conducted the final inspection, the property was not in compliance in violation of City Code 8-40, 8-52, 6-1, which regards to the building code. And that was on, the board's order was as of December 12th of 2017. And as I stated, he was not in compliance. And I also placed before the board a affidavit of prosecution costs in the amount of $148 regarding this case. And that's all I have at this time.
Does anyone have any questions for Officer Gasson? Does Mr. Burrows have any questions?
You have any questions for Officer Gatson? You have any questions for Officer Gatson?
Any questions?
Mm-hmm, for him?
No, all I want is
I understand. We're good.
Okay, you can go ahead and.
Go ahead and
This case.
speak to the board on what you want them to know.
you want me to tell them what? The city want me to tear the building down. This people here had a permit to tear the building down, to put a roof on the building. They never did it all of these years.
Okay.
So now the building is bad. The city want it to be torn down. All I'm asking for is a little time to finance part of it.
Okay.
And I'll tear it down.
About how long do you think you need? How long?
Well, the trouble about it, it is a two-part something. One is demolition, and one is asbestos.
So about how long do they estimate it will take?
I really don't know. But I really don't know. But the trouble is the asbestos, to get a contractor to come in there and do the asbestos. I got to put all the stuff on the outside to do the asbestos. And there's a contractor there that claimed he could, instead of putting it on the outside, he could put it in trailers one time, if he got permission to do it. I don't know.
Do you have any idea how long this remediation will take?
Hold on a second, sir. We need you to step up to the microphone. Tell us your name and your business address. And were you sworn in earlier? Were you sworn in? Okay. If you could speak directly into the microphone, it would be helpful. Just pull it towards you.
Yeah, my name is George Cantos. Actually, I'm here for my son. I own the roofing company. My son owns the construction company. So Mr. Bowers approached us on it to give him an estimate if the building can be repaired. If it can be repaired, he wants to demolish it. So the property is going to take anywhere from 30 to 60 days. If it needs to be demolished, it'll be about 60 days probably. By the time I get permits and all that stuff, now we can give him a price on it if it's fixable, so he can fix it. I don't know how long it's gonna take to get the permits and all that stuff. So
It's difficult for us to follow the rules without having some ideas from you of how long this will be.
we'll give 60 days. You can give 60 days on it. We have definitely, either knock it down or we have plans to proceed with the construction.
Okay.
May I say something?
Yes, please.
We got a price for the demolition
Yes.
already.
Yes.
I don't know if the man would let me out of it. I don't know. The company may not let me out of it.
Did you
But
pay
we
him
don't
something
have
already?
We don't have nothing about the asbestos yet.
Okay, I want to give you a little bit of direction here because we seem to be going off path. The question is he in compliance or not in compliance? You have an affidavit of non-compliance from the code enforcement officer. At this point, your options are find him in compliance, accept the affidavit of non-compliance, or if you want to extend the compliance date, you have the option to do that too. I don't have a form motion for you to do that, but it would be a motion just to extend the compliance date to whatever date certain it is if you wanted to do that. Obviously, you keep the pressure on to get it done. If you accept the affidavit of non-compliance, and then he can come back and petition the board for reduction of fine in the future, that's another option.
I thought we had previously established this violation.
You have. And so that's why the officer has testified that he'd gone out and inspected the property and found it to be in non-compliance. So that's where you're at right now.
Okay, I just thought I heard you just say establish the violation. So it's already established, right?
Right. I'm saying those are your options. Yes. I mean, I heard the testimony, but I'm not the one that makes that decision. You are. I'm giving you your options. Yeah.
Yeah. Officer Gasson, do you have anything to summarize?
Just, and I'm not exactly sure how it falls into there. Mr. Burrows has numerous properties within the city. He's currently in fine status on 715 South Distance to the tune of about $134,000 for that property. This is another property that's in significant disrepair. I understand that he had gotten a quote somewhere in the neighborhood of about $15,000 to tear that building down. He also was potentially looking at turning ownership over to some other parties. But that's just something for the board to consider. He is in noncompliance. The case started out, I believe, prior to Irma, and then Irma exacerbated the situation with the property and made it more dangerous and more hazardous. So that's what we're here for, is that it's simply not in compliance per those codes.
Does he have anything? Yes, sir.
It's 61 years here in Tarpon Springs. 61 years. I came here in June 1956 with Walter Carey, and I'm still here. I raised 7 kids and 6 foster kids, and I'm married 57 years. Now,
Okay, do you have anything else to say about the property?
beg pardon?
That's not related to the case.
I know that. I am just wanting to know I am not running nowhere or not hiding from nothing.
Okay.
Okay, you're
Just gonna do what you all want done. I just want a little time
okay.
to do it.
Thank you. So can we entertain a motion then?
I have a question. Is it even possible to demolish the building with the asbestos? This is for the general contractor. You can do that with the asbestos.
Yeah, you have to
without any
do an
issue.
asbestos mitigation. You have to mitigate it.
Asbestos abatement on. Depends on what zone is it. The commercial, you have to get asbestos abatement contractor to remove it. And if it's commercial, if it's residential, you don't need one. But his category doesn't fall in commercial or residential. Property. We have to find out.
Oh. I think it's mixed use. Mixed use. So he probably has to get a contractor.
Has
It
to be one or
qualifies
the
for
other.
Special use, they say, in the thing. It's not residential, it's not commercial. So we have to find out. But even if it's commercial, we have to get asbestos and pay my contractor to remove the asbestos. Rest of them, we can do it ourselves.
Okay, we need a motion.
I move that the respondent shall have until March.
Property's already in, has already been
non-compliance.
established.
Okay, that's why I was confused before. Okay. I move, based on the testimony, evidence, and facts presented in law, that the respondent failed to timely comply with this board's prior order within the time prescribed, and to award the city $148 for the cost incurred in prosecuting this case.
One second.
Second.
Any discussion?
Yeah, I'd like to know how much time it'll take them to get rid of the asbestos, and if they're gonna demolish this building, how much time it'll take them to demolish this building.
He said,
I can't hear.
he's already answered that. He said 60 days.
Okay, I can't hear well, so
I understand.
I couldn't hear him at all either.
Yeah.
Okay.
Okay. Roll call?
Ms. Norfleet,
Yes.
Mr. Robinson,
I'm sorry, I'm not certain on what we're voting on again.
The motion right now is to find the property in non-compliance and award prosecution costs of $148.
Yes.
yes? Thank you, sir. Mr. Kramer?
Yes.
Mrs. Wade?
Yes?
Mrs. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
I'll summarize. So, Mr. Burrows, can you hear me? I'm down here.
Can you hear it?
Okay. So the property has been found to be in non-compliance. The fine is running. You need to bring the property into compliance as quickly as possible to keep the fine from getting any higher. Okay? Once the property is in compliance, you can contact Officer Gasson to tell him that it's in compliance.
If you're gonna tear it down, why must it be in compliance?
You will be in compliance once it's torn down.
I don't understand that.
Right
Okay.
now, you have to pay a fine for all this process. Now, it's in your best interest to hurry up and get this done, because what you're paying for now is just the cost of all of our time. But if you
I
don't
got to
get
pay
this,
for all of this time.
if you don't get this done, you're gonna have a significant fine. So you wanna hurry up and get it done.
Now, is he qualified to do it?
The city will have to answer that.
Okay, these are the types, sir, Mr. Contos, if you could just get with the respondent after the meeting and let him understand, because obviously he's not hearing correctly. He needs to bring the property into compliance as soon as possible, whether you do it or somebody else does. And if he doesn't, the fine will begin to run. If you don't understand or he does not understand what needs to be done, you can contact Officer Gasson tomorrow or sometime after that and get the full details of what needs to be done. All right? If you could just get with him on that.
The fine is gonna start after 60 days.
No, the fine is already running.
It's already started because he was here before.
Oh, I see.
Okay?
Start the fine already. When?
Number 12.
When was the fine date?
December
The
13th.
code
fine
board,
began.
I believe, is December 9th.
Okay, so the fine's been running since December the 9th.
Oh, since December.
I'm sorry, December 12th, December.
Yes, began December
Well, that's what this date says on the affidavit. December 12th, I'm sorry.
December 12th, I apologize. Okay, we need to move on to the next case. So if you have other questions, contact Mr. Gasson after today.
Is it 140 a day? Is that a day or what is it
It's per day. It's running now.
per day?
Yes,
The
sir.
140 was the fee for today. The fine is a different amount.
Does he get more information
How much
on
is the
that?
fine?
Oh, he can get it from Officer Gasson tomorrow.
I don't have that paperwork.
Okay.
$25 a day.
$25 a day? Okay. All right, I'll explain to him, but
Okay.
Yeah, then check with Mr. Officer Gasson if you have any questions.
how do you,
Okay.
$25 a day since December? So you knock it down. no?
Madam Chairman, just so you know, 16, 17, and 18 do not have prosecution costs with them for the affidavit of compliance, so they can be lumped together if you want.
Okay.
What I want to know is, do he could take the job?
So we talk about.
Mr. Contis,
We gotta do it fast. We gotta do it fast. So we'll be, save you some money, gotta do it fast.
It don't make no saving no
Okay.
money.
Okay.
The trouble about it,
Tell him,
he said he owe
need to
me
leave.
more
Okay.
than I
go
owe.
on.
Yeah.
We finish.
Okay.
We finish. Yes, we finish.
I don't make no difference. I tell the truth.
Yeah.
He said he owe me more
Yeah.
than I owe them. I was shot. And the case ain't tried yet.
See if you can.
I was held about confined. And the case ain't tried yet. I
All right.
had counterfeit money put on me. And we went to court. And the police never showed up.
Mr. Burrow, they
I know they can't help me with that. But Channel 13 could.
That's fine.
Man, Channel 13 could. I am not wrong. I'm right. See?
We believe you.
These are clean. Very clean. This is very clean. These so clean, I don't even speak to my wife because she's dirty.
Uh-oh. That's not good.
But why should I pay?
Yeah, it's
when
all
I
right. Just
did
go ahead and
no
move
Okay.
forward.
Okay.
Why
now we
should
have the
I pay?
affidavits of compliance.
Mr. Burrows, they're moving on, okay?
Ask for a motion to accept, we can do them all at once?
Yes, you can. There are no prosecution costs on
Okay.
these.
Just the last one, there's just only one, number 19.
Oh, it's for the first
There's
three of them?
three of them that don't.
Oh, it's on another page.
And we can do the first three.
Yes, sir.
Ready?
Yep.
Yes.
I move we accept the affidavits of compliance.
You put your microphone where everybody can hear you.
I move we accept the affidavits of compliance on case 17-800000080 and case 16-800000162 and case 17-800000333.
Need a second?
Second.
Just tell you this one.
Second.
Not right now.
Okay, we're gonna do a voice vote?
Second.
Okay. All in favor?
Locoris.
Aye.
Aye.
Say aye.
Close my
Any
place
opposed?
down for 9 months. I didn't have no
Okay.
license. His dad gave me license. His dad was police.
I move we accept the affidavit of compliance and award the city $192 for incurred prosecution costs on case number 17-800000604.
I second.
Need a second?
Okay,
You got it.
all in favor?
Okay.
Say aye.
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 All any opposed? Motion
Thank you.
carries. Old business?
Yes.
Okay, we have a request to quash board order, change of ownership,
Oh, boom, boom, boom.
May 23rd.
These are the affidavits.
It's a new thing for us. Oh, yeah. Could we get an explanation?
Yes.
The property changed ownership on May 23rd, and the case should have been closed and a new case should have been opened. It slipped through the cracks, so unfortunately, this board ruled on a case that they weren't the owner of the property anymore. So we're asking for that board order under case 17-800000230 be quashed because it's not effective because the ownership changed.
I so move.
Okay.
Second.
Do a voice vote.
Okay. All in favor?
Aye.
Aye.
Any opposed? Motion carries. Okay, request to eliminate prosecution costs at 17-800000313 at 319 Hope Street.
No, we can't legally do that.
So so with this request, you can either grant it or deny it. So there'd be a motion to grant or motion to deny.
I move that we deny that.
I second.
Any discussion? Roll call.
Here's the reason.
Ms. Norfleet?
I don't know, I'm sorry that, can I abstain?
No, you need to vote, one way or the other. So the question right now is, there was a request, this handwritten request, to eliminate the prosecution costs in the case. How much was the prosecution cost, Steve?
The prosecution costs were,
$163.
$63.
Yeah.
$163.
160, how much?
$163.
Yes, 163, thank you.
Okay, thank you. So the request is to eliminate that, and I want to read to you a portion of your board rules. You weren't here the other day, you would have heard me, I read it. No petition of reduction of fine will be considered prior to the board's acceptance of an affidavit of compliance. Under no circumstances may the amount of the fine be reduced below the costs of the action. That's the portion that's important. Under no circumstances may the amount of the fine be reduced once a foreclosure is instituted. Additionally, under no circumstances may the amount of the fine for a repeat violation be reduced. Your rule specifically provides then under no circumstances may the amount of the fine be reduced below the cost of the action. So at this point, you've got a request to reduce the cost, reduce this below the cost of the action. And so the motion right now is to deny that, presumably based upon the rule. Is that right? Okay.
Correct.
Okay.
Okay, thank you. Mr. Robinson?
No.
Mr. Kramer?
No.
Ms. Wade?
Yes, I want to deny it.
To reduce it.
It is a request. The motion was to deny it. So right now, the motion is being called. And so I've heard yes, no, no.
Yes.
Okay. Mrs. Dabbs?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
It carries. It's denied.
Okay.
5-2.
Okay, now we have the approval of the minutes for November 9th, 2017. May I ask for a motion to approve the minutes?
I move that we approve the minutes from
Second.
November 9th.
Second.
All in favor, say aye.
Aye.
Any opposed? And the public comments? Did she load?
Yeah, you just can't, you can step up here and make your comments. It can't be on any case that the board has just heard today. Okay. This is not about Mr. Salikas' case, right?
Pardon?
This is not about Mr. Salikas'.
This is a general
No, we did
question,
not.
and since
Okay.
the board is all here.
Yeah, we did. I said it wrong and so did you, but we didn't reduce it. Everybody else voted yes. Yeah, we're okay.
Go ahead, man.
Oh, sorry. How long does it generally take for a complaint to be addressed? For instance, if someone filed a complaint on the 3rd of October of last year, how long would it take for there to be a response from the board?
Okay, so first of all, this is not a question and answer period. This is public comments. If you want to make a comment, you can make a comment. That's what this is for.
Okay, you don't need to lecture me like a child. I simply felt that since y'all were here, someone may be able to answer a question. If someone could answer a couple of simple questions for me afterwards, and I would
Mr.
be
Gaston
most
can do that.
appreciative of their time. Pardon me for taking up your important time.
Okay, does the city have any comment that I can make?
We do not.
Board, have any comments? Okay.
Yeah, I got a comment. I think all you guys, under his direction, is doing a heck of a lot better than we did. Oh, I've been on this thing 9 years, as you know, and he's doing such a job.
He is.
Bringing real cases with real details that we really can understand. Thank you.
You're welcome.
Okay, anything else?
You and your staff are doing a
Yes.
fine job.
And I keep seeing Mr. Weeks driving around and.
Seeing there's no other board business on the agenda, I adjourn the meeting at 4:25.
Yeah, see, you're only 5 minutes from me bringing in cocktails. See, at 4:30, I bring the cocktails in.
How you doing? How you doing?
Wow.